We're fortunate to have an expert in ethics. He's been with the State Ethics Commission for 36 years. There, he's responsible for public education, media relations, publications, and the mandatory conflict of interest training you all know and love. Please welcome Chief of the Public Education and Communications Division of the Mass Ethics Commission, David Giannotti.
Thank you so much, Lori. Thank you all for coming. I hesitate when I hear expert because I'm not a lawyer. We have an office full of lawyers. I'm not one of them. So I don't consider myself an expert on the law. I can provide a general explanation of the law, and that's what I'm here to do tonight. Hopefully, I mean, you all have had exposure, we hope, that you've completed the mandatory education components that all public employees have to complete, the training program and acknowledging the summary of the law. That gives you a basic, framework for the conflict of interest law, but they're fairly static programs, and so applying it to our daily public duties is sometimes difficult. I'll try to provide a more easily consumable translation of the law, with the goal that you will understand the law a little bit better than you did before we started. And also, I'm available to handle any questions. The only bad question is the one that doesn't get asked. So if there are real-life situations that have come up and you're unsure about whether and how the law applies, we can talk about it. Just understand that I am not a lawyer, so I don't give out legal advice. But that's the most important service we provide at the Ethics Commission, is legal advice. Because the conflict law is very complicated. There are 29 different sections. Some of the stuff is intuitive. Other sections are very complicated. And you've got enough to do learning about the rules and the laws governing your boards. And to say that you also need to be thoroughly familiar with the conflict law may be asking a little bit much. But you don't have to. That's our job. We are a resource, and you just need to know when a situation presents, when the red flag should go up. And then the answer is, don't do anything unless you understand what the compliance rules are. The compliance rules vary from stay out of the matter to you can continue to do your job, but you need to file a disclosure. And then the question is, what's a disclosure and how do I file it? It gets fairly complicated, but that's what we're there for. So I will constantly encourage and underscore the fact that we have attorneys on staff who are there to provide you, me, and everyone else who's subject to the law with free, confidential legal advice. I say confidential because the Ethics Commission is required to operate in secret. We have strict statutory requirements that say we cannot talk about what we do, except in certain limited instances. And if you follow us at all, you may understand that we've issued some decisions on some enforcement cases. The issue of whether we've received a complaint, whether we're conducting investigations, whether anyone has called our office for advice, and what, if any, advice we've provided to people, all strictly confidential. And that serves your interests. If business opportunities present, and you want to know whether you can perform your board duties or town duties and also, pursue a business opportunity that may implicate the conflict of interest law, that's what we're there for. And, what is said to the commission stays with the commission, except in limited instances. We can make public enforcement decisions. So everything is confidential, whether we've received a complaint, whether we're conducting an investigation. But if the commission decides a case that somebody has violated the law or not violated the law, and they impose some sort of penalty, what have you, those decisions by the commission are public. We are a public agency, and we have some duty to the public to be as transparent as possible. And so we have those decisions. We've issued one yesterday, one today. We'll be issuing one tomorrow, and then one probably next Tuesday. So commissions, their September meeting, they were very busy deciding various enforcement cases. But the point is, we are a resource and we want you to use it. So we're going to load up the slide deck. I'm going to talk about the conflict law by topic. Again, if you have any questions, feel free. Number one, I'm not an attorney, so I don't give out advice, but I'll explain how you can get advice. And then number two, with questions, recognizing that I work for the Ethics Commission, keep the questions hypothetical, prospective. Don't tell me you violated the law, okay? But I'll do my best to explain how the law can apply in situations. And if you've encountered situations and you are unsure, this is an opportunity to talk about those matters. So on this first slide is my contact information. If you're uncomfortable asking a question in this forum, you can reach out to me. That's my direct line and my email address. And so, Chris, you have copies of the slide deck that will be available. Chris will have copies and you can get all of this information. Okay, my clicker works, even on Zoom. And welcome to all of those who are joining the meeting remotely. We hope you get something out of this presentation. And Chris, are you monitoring the chat in case there are questions? So if you do have questions for those joining on Zoom, please use the chat feature and Chris will forward those questions to me and we can discuss them. So this first slide really looks at the conflict of interest law from its 52,000-foot view, its high-level view. In Massachusetts, the conflict of interest law is in place to ensure confidence in government, not to guarantee, but to work to ensure confidence in government. It imposes restrictions on public employees and what they can do if they encounter a conflict of interest. The general rule is, as public employees performing our duties, we are required to act in the public interest. Conflicts of interest are those situations that can undermine confidence in government because the public would become rightfully concerned in any instance where a public employee is acting in matters where their private interests are also involved. Are they acting in the public interest or are they making decisions to favor some private interest? And so the law imposes restrictions whenever those situations occur. So public responsibilities, that's the job. Private interests, what are private interests that rise to the level of a conflict? And the short answer is any tangible component of your private life. The people and the entities that you affiliate with off the job, who you are, who your family members are, who your friends are, what outside business interests you have, what nonprofits you might affiliate with, what church you might affiliate with. In any instance when you're performing your public responsibilities as a board member and some aspect of your private life is going to be affected, that's a conflict of interest. It doesn't mean it's a violation of the law. It just means that the law applies, and then the question becomes how. When you're talking about your work as a public employee, conflicts basically fall into one of two buckets: financial interest conflicts and everything else. Financial interest conflicts fall under the section of the law we refer to as the nepotism section. Nepotism and self-dealing. We are not allowed to perform our duties if what we will do will affect our financial interests, or the financial interest of our close-in family members, or the financial interest of any businesses that we affiliate with off the public job, and further on. But when we talk about that section of the law, we'll go into that in just a little bit more detail. The rule under the law is you're disqualified, you're out. You cannot perform your duties if certain financial interests are affected. And the terms we use at the Ethics Commission to reflect that are abstain and recuse. Those two terms mean the same thing in our world, although they might have a different meaning in a different context. It just means the public employee is backing away from performing their duties because they have a financial interest in the matter. Now, there are workarounds in the law. The law imposes restrictions, but in certain instances where, yes, there's a conflict, but it's not a significant conflict, or it can be cured in a certain way, there are workarounds. And there's a workaround under the nepotism section as well, recognizing that while a financial interest implicates the law, what happens if the financial interest is insignificant? Well, there is a workaround, and we'll talk about that as well. That's sort of bucket one. So bucket two then encompasses all other types of conflicts that don't feature a financial interest component, and they generally fall under the section of the law we refer to as the Code of Conduct section. And the most common type of conflict that happens every day in government is not an actual conflict. It's called an appearance of a conflict of interest. We hear all the time people saying public employees need to avoid even the appearance of a conflict. Well, there is such a thing in the law, an appearance of a conflict of interest. And that's just a circumstance. It's not an actual conflict. It's a circumstance where a public employee is poised to perform a duty, and yet some component of their private life is going to be affected by what they do. Even though the public employee will continue to act in the public interest because that is what is required, the fact is that circumstance creates the concern. And so for those types of conflicts, we don't have to stay out of those matters. We can, but that's optional. We can continue to do our job, provided that we first disclose the conflict. The conflict of interest law requires transparency. Public employees are not allowed to perform their duties with any hidden or undisclosed biases. When I say conflicts, I'll refer to private interests, outside interests, but what are essentially our biases. The people and the entities that we're predisposed to want to favor. Friends, family, businesses, or other organizations that we affiliate with. So whenever you're performing your public duties and you have a bias, a potential bias in the matter, that will need to be disclosed before you perform your public duties. You can always choose to not want to do that if you don't want anybody to know your business, and that's fine. You just stay out of the matter. But the law allows your participation despite the conflict, provided that the disclosure occurs. And we'll talk about that whole disclosure process because it serves the public interest. It helps maintain confidence in government by creating transparency. And not only by creating the transparency, but where do we create that transparency? Where do we file a conflict law disclosure? Well, we'll file it with our agency or whomever appointed us to our board position. And if we're elected, we would file it with the town clerk's office. But the whole point of filing it with the agency is to put the public agency on notice. One of the employees has a potential bias. For appointed public employees, by the filing of a disclosure, it allows the agency, the recipient of the disclosure, to then take steps in the best interest of the agency. You know, I'm poised to handle a matter and it's going to affect a family member, so the law requires that if I'm going to continue to do my job, I've got to tell my boss in writing that this matter that I'm going to handle is going to affect a family member. Then I'm allowed to continue to do my job. I've met my statutory burden. But by filing the disclosure with my agency via my boss, it then allows the boss to say, hey, maybe we don't want this, maybe let's reassign, you know, it's not important for you to handle this particular issue. So agencies have a role in managing conflicts of interest. So that's basically Conflict Law 101. Public responsibilities overlapping with private interests, and then what's the type of conflict, and then that would determine what the compliance rules are. So we've got the State Ethics Commission. I think you're all familiar with it. It's a small state agency. We're an independent state agency. We are overseen by a 5-member commission. Those members are appointed by the governor, the Secretary of State, and the Attorney General. And the setup is to keep the commission free from any sort of outside or political interference. And so our members, there's a rule on how many can be from the same political party, how many appointments by the governor can be from the same political party. Our commissioners serve unpaid. They serve a 5-year term, and they're ineligible for reappointment. So it's sort of one and done. They come in, they perform the public's business, and the commission moves on day to day to day. And every year we have a new commission member coming in and a member's term that has expired. The job of the commission is to administer and enforce the Conflict of Interest Law, which is cited as Mass General Laws, Chapter 268A, but also there's a second statute. That doesn't apply to us here. There's a second statute that requires certain state and county officials and major policymakers within the agencies to, in addition to complying with the conflict law, to file financial disclosure statements with the commission every year where they have to tell us about all of their investments and property holdings and businesses and family members and so on and so forth. And that's to comply with that separate statute. The conflict law applies to everyone who's performing services for a public agency. And for our purposes, a public agency is a state agency, a county agency, or a municipality, or an independent municipal district. People get confused. You know, sometimes I'll get a board member who's a volunteer because they're unpaid, they're a citizen volunteer, and we thank them for their service because a lot of times, not here, but in other communities, it's a thankless job because there's a lot of dysfunction. And so they're doing it on their own time. You know, they're giving back to their community. But they have to complete the education requirements because they are municipal employees, not for pay and benefits purposes, but for conflict of interest law purposes. They're providing important governmental service to the community. And because of that, they are required to act in the public interest, and so they are subject to the conflict of interest law, just like a full-time appointed town employee would be. We have our website. It's on the state's portal. If anybody is interested in learning about the law, sometimes a question will come up. You're unsure about whether you want to talk to somebody about it, you'd like some more information, so you can go to our website. We've got some useful information. Ours is not a very deep site because we can't talk about most of what we do, but whatever we can talk about is up and available on our website. I talked about enforcement cases. All of our enforcement decisions are available on our website. Legal opinions, they're confidential for the most part if it's an opinion issued by one of our staff attorneys. But from time to time, the commission will issue an opinion, and they will only do so if the opinion is deemed to be precedent. We call those formal opinions, and we're allowed to post those as long as we can redact the requester's information. When the commission first began operations in 1978, every legal opinion that was issued was a formal opinion because it was the first time the commission analyzed a lot of given fact patterns. Now, once every couple of years, maybe once every 5 years, the commission will issue a formal opinion. We recently issued one because a legislator wanted to know whether they could avail themselves of the loyalty programs that the casino, the Encore Casino, awarded, where the legislature might have had a role in licensing and things like that. It gets fairly tricky, but, given that we're new to the casino world in Massachusetts, the commission had never rendered an opinion on how the conflict of interest law would apply to any casino regulation or statute or what have you. So when new novel issues come up from time to time, the commission will issue the opinion, but for the most part, it's staff opinions, staff letters, what have you. And then we have disclosure forms that we'll talk about, and links to the mandatory education requirements are available. Now, this slide deck is just to, for anyone who would question why they have to complete the education requirements. And it's because they're a municipal employee. Even though they don't consider themselves as such, they're a citizen volunteer serving on a board. But the conflict of interest law defines a municipal employee if anybody is interested or has any question about it. And it doesn't matter whether you're elected or appointed to a municipal office or position. It doesn't matter whether you're full-time or part-time. It doesn't matter whether you're paid or unpaid. What matters is, are you performing services for the town? And if the answer is yes, then chances are, for the most part, you'll be considered a municipal employee. Not in all cases, but for the most part, we'll work from the presumption that yes, you are, and then we can work backwards to see, well, are you really? One other point. Town meeting members and charter commission members. Those folks are not public employees for conflict law purposes. Those are people, they are elected in some cases. I don't know if this is representative town meeting or if this is, but town meeting members, even though people think they're performing services for the municipality, they're not. They're conducting the legislative business of the town, but they're not working for the town. And that's why they are not considered municipal employees. Same with charter commissions. They're appointed from time to time to review how town government is set up, and they make recommendations which may or may not then be approved by the town at town meeting or by election. So those folks are the ones who are excluded from the definition of municipal employee. The education components, does anyone have a question on that at all? I don't need to spend a lot of time with it. We do have a new training portal that we launched last year to try to make it easy for our cities and towns to manage the process. The law was changed in 2009 in connection with the ethics reform law. It made changes to the conflict law, campaign finance law, several other laws, and that came about because some of our public officials got caught sticking money in places where they shouldn't have been sticking it, and it got made, the photos hit the front page of the newspapers and big scandals. And as a result, we needed to form a commission to look at whether the laws are being effective. And as a result of that work, the ethics reform law was signed into law by Governor Patrick in July of 2009, and it imposed these mandatory education requirements, a recognition that the conflict law is fairly complicated and that government needs to do more to educate its employees on their legal obligations. You just can't turn them loose and expect them to understand these complexities within the law. So there's the two components. I'm always advocating that, we shouldn't have to do both in a year. It should be an off-year requirement for both, but thus far my pleadings have fallen on deaf ears. I think it was a result of research into how other governments are handling training, and they decided that they'll select the best of both worlds, which is e-learning and a document. Some were using documents, some were doing e-learning, and so the powers that be here say, well, let's do both and see how that works out. So that's the law of the land. The summary of the law is an annual requirement. When people ask, why do I have to do this every year? Statute requires it, and until the statutes change, that's what we have to do. The online training program, which takes about an hour to do, that's an every other year requirement. But the thing is, in year one, we have to do both, and then in year two, we just have to do the summary, and then year three, we have to do both, and so forth. So if you've been in government or on your board for a while, you're used to this process. Hopefully you find the latest offerings that we launched last year a little bit easier to deal with. So legal advice, it's the most important service that we provide at the Ethics Commission. You're entitled to receive free confidential legal advice on the conflict of interest law. We get over 6,000 calls in a year to our attorneys, and we have 6 attorneys handling those calls. So if you do the math, they're pretty busy all the time. But don't be afraid to call us, because everybody else is. In most cases, it's a 5 or 10 minute phone call or a quick email exchange, where it's just a quick question. I have this opportunity that's presented. Can I do it? Can I serve on this board and also serve on this board? Can I serve on this board and be appointed to this position? Can I serve on this board and represent this company that is going to have an application before my board? Or I serve on this board and my employer is going to have an application before my board. What does the law require? Or I'm poised to consider an application and it's my good friend who's the applicant, or it's my neighbor, or it's a family member. What does the law require? Do I have to stay out of the matter? Or do I have to file a disclosure? Do I need anybody's permission? Those are the kinds of questions we deal with every day. So if a situation comes up and you're unsure about what the compliance rules are, please call us. Oops, I'm not done yet. So, however, the second to last bullet point there, a couple of caveats there. We are required to keep matters confidential, so we don't give out third-party advice. And what that means is we can talk to you about how the law applies to you, but we can't talk to you about how it applies to someone else. I say that because on occasion, people are inhibited or reluctant to call the Ethics Commission, so they might ask somebody in the clerk's office, would you call the Ethics Commission and find out whether this is okay? And then they'll call and we'll explain, have that person call us directly. And part of it is the filtering that can go on. When we're talking about the law, it can get a little complicated. And if it's a complicated situation and we're explaining, okay, these 5 things you have to consider. And we're talking to some third party who's going to relay that information, they probably heard 3. And then they relay those 3. And the person they're talking to who needs the advice only heard 1. So you can imagine the miscues that can happen. So we want to talk to the person directly so that we know we're communicating effectively and that they understand what the law requires of them. So we don't give out third-party advice. We also don't give out past conduct advice. Conflicts of interest happen every day in government. They may never happen to you, but they happen every day. They're not to be feared, they're to be managed. You manage them by getting out in front. Getting out in front, step one, means knowing when you have a conflict. Public responsibilities, private interests, when there's an intersect, red flags should go up. And then don't do anything until you understand what the compliance rules are. If you do, fine, we hope you comply with the law, but if you don't, or if you're uncertain, call our office. But you have to do that up front. It doesn't help to take a chance, violate the law, and then try to get an opinion afterwards. Our legal division can only give advice prospectively. So if you call after the fact, they'll say, sorry, we can't assist you in this, but our enforcement division will be very happy to assist you. Because once conduct happens, it's not within the purview of the legal division to give advice prospectively. It's then the enforcement division reviewing whether the law was violated or not. So it's always important that if a situation comes up, you get out in front on those issues. And then if you're getting out in front and you call and you learn, okay, I can continue to do my job, I just need to file a disclosure, that disclosure has to be in place in advance as well. That's getting out in front. And what I want to tell people when we talk about the law is don't assume something is not a big deal, and don't assume that nobody's going to find out, because I can point you to all of our enforcement cases where people guessed and guessed wrong. Getting out in front on these issues goes a long way to maintaining confidence in government so that people don't get the wrong idea about your motives. You're here to do a job, and a lot of times it's a thankless job. The last thing you need is somebody questioning your integrity or your intent or motives. So you want to get out in front, make sure everything is clear so that the public doesn't get the wrong idea about what's going on. And so when it comes to conflicts, get out in front on those issues. That's the best way to keep everything moving the way it should be. So disclosures, what you're looking at here on this slide is an example of the most common disclosure that's used, a disclosure of an appearance of a conflict of interest. We have prepared forms. You don't have to create a conflict law disclosure out of whole cloth. We've got done all the work. You just have to know which form. And that's the tricky part, because we have over 30 different forms, because there are 29 different sections of the conflict of interest law. And plus there are a host of regulatory exemptions, regulations, if you will, that create safe harbors, where the facts might implicate the law, but if you follow the regulation, it won't be a violation. And a lot of times that calls for the filing of a disclosure. So this is a typical disclosure form. To comply with the conflict law, it is not sufficient just to tell someone, hey, I know this person, or I think I have a bias here, because that oral disclosure disappears into the ether the moment it's stated, never to return again. We're conducting the public's business, and there's a written record of how the public's business is conducted. And so for whenever a public employee is participating in the public's business and they have a conflict, that disclosure of that conflict, provided that the law allows them to continue to do their job, provided they disclose it, that disclosure has to be in writing. It becomes part of the public record. And to comply with public records law requirements, the recipient of a conflict law disclosure has to maintain it for 6 years. Now, the disclosure also has to contain all the relevant facts. If somebody shades a disclosure and they conveniently leave out an important fact, it's an imperfect disclosure. It does not comply with the law. The disclosure has to contain all of the facts that constitute your bias. It could be as easy as, I'm on a board, we're going to decide this application. The applicant filed suit against me 10 years ago. I don't like the SOB. Do you have a potential bias there? You absolutely do. Those are relevant facts that have to be a part of the disclosure in order to comply with the conflict law. Now, where do we file a disclosure? It depends. If you are appointed to your board, then whomever appointed you to the board, usually it's the Board of Selectmen, that's where you would file a conflict law disclosure. If you are elected to your board, then you don't have an appointing authority. You would file the disclosure with the town clerk's office, and they have to be maintained as public records, available upon request, so that the public can have confidence in the work that we're doing as public employees. So let's talk about the law. Everything up to now has sort of been housekeeping. We're going to talk about the law by topic. Topic 1, gift restriction rules. The Conflict of Interest Law imposes restrictions on whether a public employee can receive a gift from someone. Why? Because gift giving in the public sector can undermine confidence in government. The public, looking at how the public's business is being conducted, would become concerned in any instance where they learn that a public employee has received a gift from someone that they're then making important decisions about. It doesn't restrict gifts universally. It only restricts gifts if the public position is implicated in connection with a gift. In other words, gifts from friends and family during holidays or events of personal significance, there's no issue under the law. But if your public position is tied into the gift, then red flag needs to go up. And these bulleted items are the specific gift restriction rules. The top one, bribery. Don't have to spend a lot of time on that because this is one of the intuitive parts of the law. We all know that. But the law applies to both parties in a bribe, the public employee and whoever bribes or attempts to bribe. And the law applies even on an attempt. The deal doesn't have to be consummated. Bribes are corrupt acts, and the corrupt element of a bribe is something called a quid pro quo. And that's just means an exchange. I give you this, you give me that. Classic example, so I'm traveling to a meeting out in Western Mass and I'm late and I'd like to make up some time, so I'm on the Pike. The speed limit on the Pike is 65. I see a little opening. I tool it up to about 90 and I didn't see the trooper, but the trooper sure saw me. What's the chances I'm going to get a speeding ticket for going 90 in a 65? About 100%. So when I'm asked to produce my license and registration, I tuck a $100 bill in the mix. I don't say anything, I just tuck a $100 bill in the mix. Everybody there knows what that means, quid pro quo. Where the trooper would write a speeding ticket 10 out of 10 times for somebody going 90 in a 65, I'm going to try to leverage that situation using that $100 bill to get that trooper to not write a ticket in my instance. That's a bribe. If the trooper were to accept the bribe, the trooper would violate the conflict law. The mere fact that I offered the bribe, I violate the conflict of interest law. Because bribes are corrupt acts, and this is the most serious violation under the law, the commission, which operates under the rules of civil administrative procedure, we don't criminally enforce the law. The AG can in certain instances. We civilly enforce. But for civil penalties that the commission can impose for this bribery section, it's up to $25,000. For all of the sections, it's a civil penalty of up to $10,000, depending on what the commission decides. The middle bullet point deals with what we call illegal gifts and gratuities. And for those of you that might be familiar with the $50 rule, this is where that comes in. The conflict law says it's a violation for anyone to offer or give to a public employee or for a public employee to solicit or receive. Again, deal doesn't have to be consummated. The mere offer triggers a violation. A mere solicitation triggers a violation. But the offering or giving of an item of value that's $50 or more given to a public employee for or because of some official act performed or to be performed. Now, that language doesn't implicate a quid pro quo. A quid pro quo, there's an explicit understanding that for some item of value, this is what's going to happen. Public employee agrees to do something, agrees not to do something, or there's some collusion to commit a fraud on government. In an illegal gift and gratuity, there's no quid pro quo. It's just a gift given. The language implicates a business nexus. A gift worth $50 or more given to a public employee by someone with whom the public employee has official dealings. Again, both parties can violate the law, but there's no corrupt element there. In most cases, it's to say thank you, to express appreciation. But again, when you're in the public sector, the public will be very concerned about instances where public employees are receiving gifts from the very people they're making important decisions about. The law imposes this $50 rule because that's a presumption. For something worth $50 or more, there is a presumption that the public employee could be improperly influenced. Not will, could. At what value of a gift could a public employee be improperly influenced? And what we mean by that is where their decision-making might be altered, where they would decide a matter 10 out of 10 times this way, somebody gives them a gift, would they decide the matter differently because of the gift? So what the law says is $50 or more, there's a presumption that the public employee could be improperly influenced, and such gifts are prohibited, so that we don't have to get into whether somebody was or was not improperly influenced. Gifts worth less than $50, not prohibited. We'll talk about that in a bit. The threshold gift restriction rule takes out the business nexus. It just says you cannot accept a gift worth $50 or more that's tied to your public position, for or because of public position. And so in any instance where somebody has given you a gift and it's in town hall or it's in connection with the public's business, red flags should go up. My advice is don't ever accept a gift from somebody if in connection with your public duties, because people looking at that can get the wrong idea and frequently do. But the law doesn't prohibit you from accepting a gift worth less than $50. But if a gift is given to you, even by somebody where you have no business dealings with them, they come into town hall and you're just getting out of your board meeting and they say, you know, and they only know you from your board position, and they say, hey, my company has Red Sox tickets for this weekend, we're not using them here. That could implicate this section of the law. Public employees cannot accept any item valued at $50 or more that is given to them because of their public position. So gifts worth less than $50 don't violate the law, but that doesn't mean there's not a compliance rule. I talked about appearances of conflict of interest. Whenever you're poised to perform your duties and some component of your private life is going to be affected by what you do, the public will become concerned about whether you're acting in the public interest. Guess what? Whenever somebody gives you a gift, you now have a private interest. Why? Because in the normal course of things, we have official relationships. We are the public employees. Those are the people subject to our authority. Those are the people with whom we have official dealings. There's this, line between public employee and person who needs something from the public employee. Gift giving tends to mute that a little bit, attenuate that a little bit. It makes the relationship more personal. People don't give gifts because you're a public employee necessarily. They give you gifts to become friendlier with you, to make your relationship more personal. And sometimes people will use gift giving to public employees in an effort to leverage a relationship. You might have certain people that are constantly looking for stuff, permits, inspections, or what have you. And it's important to them that whenever you see them coming through the door, that you do a lot of this. They don't like it when we do that. And sometimes gift giving is a way to leverage that, so that to the extent there's any gray area or benefit of the doubt, that person who needs something from the public employee will get what they're looking for. They'll get that benefit of the doubt. At the public expense, we're required to act in the public interest. And sometimes we're making decisions involving competing interests. We're on a procurement team. We're looking to buy something. And we've got different people who want the yes. And then one of those bidders takes us out to dinner or gives us a gift. What are those other bidders going to conclude about the whole process? They're going to conclude it was corrupted. And that's why it's important. Whenever somebody gives you a gift, be careful. If it's in connection with your public position, even if it's a gift to a spouse by somebody that you deal with, understand they might be trying to use the back door to leverage their relationship with you. Not that that's ever going to happen. I'm sort of giving you worst case scenarios here. But what I want to emphasize is, if a situation comes up where somebody provides you with a gift, chances are you're never going to see it coming. If you don't think about this stuff in advance, sometimes you might not react appropriately. If you decide, hey, in connection with my service to the town here, I am not going to accept one dime from anyone. So that if the situation comes up out of the blue where you didn't see it coming, you've got that trained in your mind. If you don't, then you've got to think quick. You know, should the red flag go up? Is my public position tied in? You know, you may be friends with someone off the job. You know, you have golfing buddies, or you socialize, you go hiking or biking or what have you. And so there's a social component to your relationship. Then all of a sudden, they're before your board and they need something. And then in connection with that, the next time you go out golfing or hiking or biking and you stop for refreshments, they're then picking up the tab. You know, you have to think, is this tied into the fact that we have a social relationship? Or is this tied into the fact that they have a matter pending that I have to decide? Or is there a mixed motive? Sometimes it can be a mixed motive. We had a case involving friends, and they were going through the engineering program at one of our schools, and they graduated. And when they were in school, they did what college kids do. They go out and they socialize, and sometimes one paid, sometimes the other paid, and so forth. Then they graduate and they moved into their careers. One of them went to work for a town in their engineering department. Another one went to work for one of the big engineering firms that do business with municipalities. And this firm had matters going on with this municipality, projects. And they had an annual engineers conference, and these folks were both civil engineers in their different capacities. And the one who worked for the private firm was going to the conference, and he called his buddy who worked for the town and said, "Hey, are you going to the conference?" "Yeah." "Well, I bought a foursome for the charity golf tournament that's a component to the conference. I need a fourth. You want to jump in on that?" I said, "Sure." Now, using their experience and their social relationship, where sometimes one would pay, sometimes the other would pay, you know, this person thought that his buddy was going to pick up his greens fee for the charity tournament. But what did that guy do at the end of the conference? He expensed it. So it was the company who paid the greens fee for the town employee. You know, and so he didn't see that coming, they didn't think it through, and then oops, mixed motive. Yes, there was a social component to the gift, but then also there was an official relationship, and that's problematic. So those are the kinds of things that people aren't just going to be able to think about on the fly. So it's always a good idea to have, you know, think about this stuff and have a firm plan if something happens. Gifts worth less than $50 are not prohibited, but those situations create an appearance of a conflict of interest. Not in all circumstances. Let me give you an example. So say I'm a school teacher, and the parents of one of my students have given me a $40 gift certificate to my favorite restaurant. I can accept it because it's not worth $50 or more. If it were, I'd have to refuse it. $40, I'm okay. Does it create an appearance problem? If the answer to that question is yes, then while I can accept the gift certificate, I would then have to follow up with a written disclosure with my appointing authority, the principal. Let them know I got that gift certificate from the parents. But not all circumstances create appearance problems. Most do. But for example, if I were to get the gift certificate at the end of the school year, such that as a teacher in my official dealings with people, I'm not going to have any further official dealings with the parents, it's at the end of the school year. That circumstance does not create an appearance problem. I can accept the gift certificate. I don't have to tell the principal in writing that I got it. But if I got that gift certificate in the middle of the school year, where I am going to have continued dealings, official dealings with the parents, that does trigger an appearance problem. The appearance problem does not occur when the gift is received, the gift worth less than $50. It's triggered at the point that the public employee, after receiving the gift, is going to have official dealings with the gift giver. At that point, the disclosure of the appearance of a conflict of interest has to be in place with the appointing authority. Gifts that are prohibited, these bulleted items, these are the most common types of issues we deal with at the Ethics Commission regarding the gift restriction rules. It's the payment of meals, vendors paying for meals for public employees, event tickets. There's a reference to an advisory in 2004. The commission issued an advisory on event tickets. Now, what was going on way back in 03 and 04 that might cause the commission to issue an advisory about event tickets? Patriots and Red Sox. And we were getting an uptick in requests for advice from public employees saying, I've been offered tickets to the playoff game from the vendor, the face value of the ticket is $45. I can accept it, right? And after they were done crying, when we explained that, no, you may not, the commission explained in the advisory that we're not going to necessarily use face value to determine the cost of the gift. What was the value of the gift you received? The commission said, we're going to use actual value. And if the actual value exceeds face value, it's going to be problematic. If the total value of the gift is $50 or more, it's going to be problematic. And if you try to get a ticket on the secondary market to a Red Sox or a Patriots playoff game where the face value of the ticket is $40, what are you going to have to pay for that? A lot more than $40, a lot more than $50. And so the commission explained that for ticketed events, we're going to not necessarily use the face value of the ticket to establish the value of the gift to you. Also, travel and expense reimbursements, the gift certificates, floral arrangements, and fruit baskets, lottery tickets, quiz. Somebody comes up to you in town hall and they only know you as a town board member, and around the holiday season, they hand you a $50 scratch ticket. Can you accept it? No. Costs the giver $50 or more. What happens if you succumb to the temptation and you scratch the ticket and it comes up goose eggs? It still costs the giver $50 or more. It's still a violation for both of you. What happens, however, if somebody comes up to you and hands you a $2 scratch ticket? Can you accept it? Yeah, it's not $50 or more. What happens if you scratch it and you win $10,000? It's your lucky day. It only costs them $2. You can keep the winnings. But would that circumstance create an appearance of a conflict that would require a disclosure? In most cases, probably yes, because you think, well, who would come up to me in my office and hand me a $2 scratch ticket? Well, only somebody that knows me, and that's probably somebody that I have dealings with. So, question?
So, a follow-on to that, $49, is there a annual or?
Sure.
Is there an annual or some other kind of cap? Because you could do, if I got 20 $49 gifts,
Right.
obviously,
Right.
right? So that's
What you're talking about is aggregation. And so, but what we're talking about is separate gifts, all worth less than $50 from the same source. Multiple instances from a single source. And the commission will aggregate those. And the example I would use is that of a public employee overseeing a vendor. And, we're busy, we're trying to get this project moving along, tough to schedule meetings during the day, so we agree to meet for lunch. And we order lunch, and the vendor pays for my lunch, and it's $20. Can I accept it? Well, yeah, it's not $50 or more, so it's not a problem. Would it create an appearance problem such that I would then have to let my boss in writing know that the vendor paid my lunch? Most definitely. But it doesn't violate the law. What happens if a couple of months later, same circumstance? Can't carve out a meeting during the work hours, so we meet for lunch, and same scenario, and they buy my lunch, and it's $20. Well, the commission can aggregate those individual events from the same source. So that's total of $40, still not $50 or more, so it doesn't violate the law, but it would trigger another disclosure to my appointing authority. If there were a third instance, then in the aggregate we would get over $50, then it would be a violation. Now, how far do you have to look back in aggregation? Forever? No. 365 days. So in my example, whenever I get a gift from somebody that's worth less than $50, and it's not the first time I received a gift from that entity or that person, I have to look back and see what were the prior instances and add them together to see what the total is. If I have $20 and then last month and $20 6 months ago, and then $20 on day 366, well then I haven't violated the law, because we only have to look back 365 days. But I couldn't accept a lunch today, because then I'm at $40. If I were to accept one now, that would put me over and it would violate the law. Gifts offered through sales promotions. Any item of value in any way, shape, or form, tangible or intangible, conveyed to a public employee can implicate the gift restriction rules. I had a case years and years ago involving a food services director. And the job of the food services director was to manage a finite budget for the school department. And so this person was dealing with all of the food wholesalers. Now, what do people that sell products and goods, what do they want to do? They want to sell. And so how do they sell? They provide inducements. And so while the food services director was required to manage the budget to act in the public interest, the food services director was tempted by the inducements offered by the food wholesalers. I'm dating myself now. Way back when, they were iPods, the Apple Music devices that, I don't know if they're still available anymore, but the iPods and the iPod minis. Well, and this food services director, rather than order to manage the budget, was ordering in order to qualify for the iPods because she thought they would make great gifts for the grandchildren. Now, who owns those iPods? They were paid for with taxpayer money. The municipality, the district, owns those iPods. Maybe the school library could have made good use of those. But instead, she collected them and she gave them to family members until the district found out. And then we found out. And I don't think that she appreciated what would happen by something like that. Didn't think about it. Didn't think it was a big deal or didn't think anybody would find out. And then we did. So after the commission was done, it took enforcement action and issued a decision and issued a penalty for the violation. Then what happened? Then she had to go back to work. And then what happened? She lost the job. It's just not what the Ethics Commission can do to you in these kinds of situations. You then have to face your employer and whatever issues they want to bring out. So, okay, so those are the gift restriction rules. Bribes prohibited. Gifts worth $50 or more prohibited if tied into the public position. Gifts worth less than $50 not prohibited, but a disclosure may be required depending on the circumstances. Now, there are regulations relating to the gift restriction rules, where the commission has looked at real-life situations and said, hey, although these circumstances might implicate these restrictions, if the regulation is followed, it won't be a violation of the law. And so those bulleted items constitutes categories where there might be exemptions from the gift restriction rules, safe harbors, if you will. And so I'll just talk about a couple of them. The first one is the most common one that's used. Travel expenses where the purpose of the travel serves a legitimate public purpose. The commission looked at opportunities for public employees to attend training and educational events where the public agency might not be able to pay for it, but some private entity is willing to pay the expenses for the public employee to obtain additional training. Does the public benefit, this is the commission's view, does the public benefit if public employees have opportunities to receive additional training? Of course. And does the public benefit if the public agency doesn't have to spend its money to provide that training? Yes. And so the commission promulgated a regulation that said we're going to allow public employees to attend business meetings or legitimate public business events and have private entities pay those expenses as long as they follow the regulation. The regulation requires a written disclosure by the public employee of the event, of the travel, and that has to be filed with the public employee's appointing authority, and then the appointing authority has to sort of endorse. They have to be, are required to make a determination on that disclosure form, which is a public record available upon request, that the employee's attendance at the event serves a legitimate public purpose. And if that disclosure is filed to create transparency, and if the agency endorses it by making that determination by the appointing authority, then it doesn't violate the conflict law. But the thing is, it doesn't allow wining and dining or junkets. These are events that serve a legitimate public purpose. Now, who makes that determination? Not us. You know, we're lawyers and professional staff sitting in Boston. We have no idea what constitutes a legitimate public purpose for the town of Concord. The town of Concord gets to make that determination as to what is and is not a legitimate public purpose. Unsolicited perishable items. There are employees who might be overseeing vendors, and out of the blue, the vendor, you know, it's a long project and it's been tough, and out of the blue, the vendor might send the public employee a floral bouquet or an edible fruit basket. Not uncommon. The gift restriction rules are implicated because those items all presumptively cost $50 or more. The delivery charge gets you up there pretty good. But the fact is, those are items of value conveyed to a public employee. So on its first blush, they're restricted by the conflict law. But by regulation, the commission has said, we're going to allow public employees to accept unsolicited, that being operative, perishable items, food items, floral bouquets, what have you. Recognizing that nobody's trying to bribe or improperly leverage a relationship with a public employee over a bouquet of flowers. So we're going to allow that as long as the public employee does not accept those items for their own use. They don't get to accept them and take them home. Instead, the public employee accepts them on behalf of their public agency. Because the conflict law is designed to restrict gifts to public employees for their personal use, where there may be an effort to improperly leverage a relationship. Gifts to public agencies are not restricted. The town or the city can accept gifts of any value for the stated purpose as long as it has a policy regarding the acceptance of gifts. Usually there needs to be a written policy. Usually it has to be done through the Board of Selectmen. And you can gift to the town anything you want, even if it's got a stated purpose. If the town is willing to accept the conditions of the gift, then they can accept the gift. So with unsolicited perishable items, if I were to oversee a vendor and out of the blue, the vendor sends me a floral bouquet because they know I like flowers, I can't put it in my office or take it home. Instead, I have to put it in a publicly accessible area for everybody to enjoy equally. I accept it on behalf of my public agency and put it on display in a publicly accessible area. If the vendor were to send an edible fruit basket, I'm allowed to take that to my office, discreetly pull out those chocolate-covered strawberries and leave the apple slices and pineapple for everyone else, as long as I'm accepting it on behalf of the town and I then share the items. So those are some regulations where the commission has said, yeah, these circumstances implicate the gift restriction rules, but there's not a lot of harm here, or there's a definite benefit to the public to allow it, you know, or it's to recognize this is an everyday occurrence and shouldn't be viewed, you know, dimly by the public. The bottom of the slide, you see the reference to an advisory on gifts and gratuities. So the advisory we have is generalized advice explaining these gift restriction rules. If anybody would like more information, we encourage you to go to our website and review the advisory. And so there are additional ones, these bulleted items, again, categories where exemptions from the gift restriction rules may be available. Class gifts to teachers. We have a regulation specific to teachers, recognizing that especially at the elementary school level, it's customary for teachers to receive gifts from parents or students. And so while the conflict law imposes this $49.99 restriction on public employees, teachers are allowed to accept class gifts of up to $150. As long as it's a class gift and the individual contributors to the gift remain unidentified. Why? So that the teacher is not put in a position where they could be improperly influenced. They don't know who gave. The regulation further provides that if a teacher were to receive a class gift and then a parent or a student were to come up to them and provide a gift of up to $49.99, the teacher is duty-bound to ask that person, did you also contribute to the class gift? Because you cannot do both. And then finally, the regulation provides, recognizing that teachers frequently go out of pocket for classroom expenses, recognizing that the regulation says people can provide gift cards to teachers of any amount, where the express purpose of the gift card is to reimburse actual classroom equipment and supplies. So I could provide my child's teacher with a $400 gift certificate to Staples if I wanted to, and they're allowed to use that. We tell teachers, if you get such a gift card, save your receipts. We reserve our prerogative to verify that nothing went to you personally. We then advise, hey, it's a lot cleaner if a company wants to do that, to recognize the work of the teachers. Provide those gift cards to the school department with your express wishes as to how they're to be distributed. And then if they're willing to do that, let the public agency get in the middle of that to make sure that nobody is improperly influenced as a result of the gift card. Okay, those are the gift restriction rules. Now we'll talk about the nepotism rules, financial interest conflicts. This section of the law says that you as a public employee, as a municipal employee, you may not perform your duties if what you will do will affect certain financial interests. And then there's basically a list. You may not participate in matters if your own personal financial interests are going to be affected, positive or negative. It doesn't matter. If there's a financial interest impact, this section of the law applies. Also on the list, your immediate family members. Not all of your relatives, your closest in ones. We're talking spouse, siblings, parents, children. And we'll look at that on the next slide. But everyone else, not part of this. Also, if you have a business partner or if you have private employment, you're privately employed or you own or operate a business. As a public employee, you may not perform public duties if what you do will affect the financial interest of any business organization that you affiliate with. And then finally, if you're negotiating for employment with anyone, and as a public employee, you also are involved in matters that will affect their financial interest. At the point you begin negotiating for prospective employment, this nepotism section applies. And when I say applies, it means you must stay out of matters affecting financial interests. You must abstain or recuse from any participation once financial interests are impacted. Now, I mentioned workarounds. There's a workaround here recognizing that while any financial interest, positive or negative, implicates this section of the law, what about insignificant financial interests? Still implicates the law, but there's a workaround in the interest of government efficiencies that says for insignificant financial interests, there's an option here. The public employee who has the conflict can file a disclosure with their appointing authority, and the appointing authority then has to decide what to do about it. The public employee cannot, because that would constitute participating in a matter they're not allowed to participate in. The appointing authority who receives that disclosure can do one of three things: take responsibility for that issue and handle it, assign that matter to somebody else to handle, or the third thing is, if they're willing to make a determination on that disclosure form that the integrity of the services that they can expect from the employee will not be impacted, it waives the statute. Bottom line under the nepotism section, for appointed public employees, you cannot participate in matters affecting certain financial interests unless the boss, in writing, says it's okay. And it's done so through this disclosure determination process. If you are an elected office holder, you don't have an appointing authority, so this workaround is not available to you. If you encounter a financial interest conflict, your response is always, you must abstain from the matter, stay out of the matter. Question?
Sorry. So is there a different disclosure form for that? Or
Yes, there is. As I said, we've got over 30 different disclosure forms on our website. If you were to go to our website and try to find the right form, your eyes will glaze over. So we always advise that if you've got a situation and you think I might have to do a disclosure, then guess what? You need to call the office and talk to an attorney in our legal division, because they're the ones that will be able to confirm whether your situation implicates the conflict law, and then if so, how. And if there is a workaround that allows you to file the disclosure, they'll be able to get you to the correct form. Some of it, if you look at the forms, it gets subtle. You know, the distinction between disclosing an appearance of a conflict of interest and filing a disclosure regarding travel that serves a legitimate public purpose. very subtle because they both involve the same code of conduct section of the conflict of interest law. So on this slide, we're looking at a chart that includes immediate family members. That term, immediate family, is defined in the law. It's reflected on the chart. As I said, it's you, it's your spouse if you have one, but it's your parents, your siblings, and your children. And your spouse's parents, siblings, and children. You may not perform your public duties if what you will do will affect your financial interest or theirs. Well, this then begs the question, what about other family members who are not immediate family members? We'll call them non-immediate family members. First of all, who are they? Cousins, aunts and uncles, nieces and nephews, grandparents, grandchildren, ex-spouses, domestic partners. Not on the chart, not an immediate family member. Not an immediate family member, not a nepotism issue. But that doesn't mean that the law doesn't apply, because I've been talking about appearance of conflict of interest. If you're poised to award a contract to your brother's company, is that a nepotism issue? Yes, it is, because brother is an immediate family member. But if you're poised to award a contract to your nephew's company, is nephew an immediate family member? No. Well, what does the conflict law say about that? Well, appearance of conflict of interest. Would it create an appearance of a conflict if you were to award a contract to your nephew's company? Of course. But because nephew is not an immediate family member, you may proceed in your duties, provided that you first file the disclosure that you're poised to decide a matter which might result in awarding a contract to your nephew's company. What's the best course of action in that scenario? Well, following the law, you can file a disclosure and continue, but do you want the fallout that can happen if you award a contract to a family member? Perchance no. The wisest course might be to stay out of it, even though the law allows. Because a lot of this stuff is not just letter of the law, how do I comply? A lot of this stuff is optics. Thinking about a situation, thinking about how people can get the wrong idea, and then making decisions that say, do I need to do this? Sometimes the answer is yes, I do need to do this. Other times it's, I don't need the aggravation I'm going to buy, if I handle this matter, where I can just as easily stay out of it and save myself a lot of heartache. But you have to make those decisions. Now, for board members, if you are elected and you encounter a nepotism issue, the workaround is not available to you. Example, so I serve on the planning board, and it's a 5-member planning board, and we're elected. And we decide all subdivision matters in the community. I understand the site plan review and all the different boards that might get involved. But for the purposes of my example, the planning board decides all of this stuff. And I serve on the planning board, and there's 5 members. And Walmart has just filed an application. They want to put in a big box store right next door to my house. Is that a matter that's going to affect my financial interest? Most definitely. Now, 2 of my fellow board members also live in my neighborhood. They're also impacted. They're abutters. They also have a financial interest conflict, so they can't participate either. All of a sudden, 3 of the 5 planning board members have to abstain because of financial interest conflicts. The board can't decide the matter. Well, that doesn't work. The board should always have a way to decide these matters. I can't pursue the disclosure determination process because I'm elected and I don't have an appointing authority. If the planning board was appointed, then in this situation here, I would just file a disclosure with my appointing authority, the Board of Selectmen, and they would decide what to do about my situation, which could involve allowing me to participate, though that wouldn't necessarily be the best exercise of judgment. But in any event, for elected board members, it's not available. What is available is something that's not in the conflict law. It's just something that the commission has adopted. It's called the rule of necessity that was elaborated upon in a court decision. The rule of necessity can be invoked, and it allows people with conflicts to otherwise participate in the matter. But there's a process that has to be followed, and so we have this advisory at the bottom of the screen. If an elected board cannot act because it cannot put a quorum together, the rule of necessity might be available. But to invoke the rule of necessity, there's a process. First, the board needs legal advice. Would it be appropriate to invoke the rule in this And that's where either town council or the commission's legal division would be called in to render advice whether it would be appropriate to invoke the rule. And then if the answer to that question is yes, it would be appropriate to invoke the rule, and an analysis has to be done. Are you all abutters? Do you all have a financial interest conflict? Because the answer might be no, only 2 of you have it, and then the board can put a quorum together. So is this an appropriate use of the rule? Have we validated that, yes, you can't put a quorum together? You get legal advice for that, and then at the meeting where the important decisions have to be made, one of the members with the financial interest conflict would invoke the rule. And then all of the members who have financial interest conflicts must state for the record the nature of their conflict. And it's got to be available in the meeting minutes. Once that's done, then all of the board members, even the ones with the conflicts, can vote on the matter. They're not required to. You can still abstain. The rule of necessity merely permits conflicted board members to participate if the board cannot put a quorum together. It's important that legal advice be obtained because sometimes it's possible to improperly invoke the rule. And if a board improperly invokes the rule, they don't get the protections that the rule allows. We had a case years ago involving, I think it was a 7-member city council, and there was a very controversial development issue coming about. 4 of those members had conflicts. 2 members had financial interest conflicts. They were tied into the development application, either as abutters or they were employed or their spouses were employed, what have you. 2 members had conflicts, but they were not financial interest conflicts. They were the type that could be cured by the filing of a disclosure. They only had an appearance of a conflict of interest. The board chair was one of those people that had a financial interest conflict, and he wanted to participate in this matter. It was very controversial, and he wanted to participate. So when the time came for the board to act, he invoked the rule of necessity, saying 4 members have conflicts, so we can't put a quorum together, so I'm invoking the rule, and then we can all vote. And then we learned about it. And we were able to analyze whether they had conflicts and what type of conflicts, and the commission decided you 2 had financial interest conflicts, you had to stay out of the matter. You 2 had conflicts that could have been cured by the filing of a disclosure. This was an inappropriate, improper invocation of the rule. You don't get the benefit that the rule provides. You 2 get the checkbooks out. This one's going to hurt. And the commission took action for that, for those 2 who violated the nepotism section of the conflict law by improperly invoking the rule. So this advisory explains what's required if a board is faced with that kind of a situation. What about situations where somebody needs to abstain? What is the appropriate way to abstain? Because we see different things happening, and sometimes it creates confusion. Sometimes we see somebody sitting at a board saying, I'm abstaining, and they remain at the board, and it raises eyebrows. Other times we see situations where somebody abstains and then they go sit in the audience. And then we see situations where somebody abstains and then they leave the room. Which one is correct? A, B, C, or D, all of the above? And it's D, all of the above. If a board member has to abstain because they have a financial interest conflict, the law just requires that they not participate. That means they cannot discuss the matter, they cannot vote on the matter, they cannot swap hand signals, they cannot glare, they cannot advocate with their fellow board members outside of the meeting. No participation. But if a board member has to abstain, and it just means they don't participate, they can say they're abstaining and then just remain at the table. But is that the wisest judgment in that situation? Because even if you're not violating the conflict law, there are situations when I talk about you've got to look at the optics. It's not unheard of that the Ethics Commission will get a complaint about that. And the complaint will be, this person participated in the matter, even though they said they were abstaining. And whenever we learn that there's a possible violation of the nepotism section, we're going to look at it. We're going to want to satisfy ourselves that there was no violation. You know, and the nature of the call, well, what do you mean they participated? Well, did they discuss the matter? Well, no. Well, did they vote on the matter? No. Well, what did they do? Well, they were glaring at their fellow board members. They were intimidating them. Or by their very presence, he was able to hear and what his other board members would say, and he would retaliate against them if they did not act in his favor. Well, that's all hogwash. That never happens. The person didn't violate the law because they did not participate, but they did not insulate themselves from a possible complaint to the Ethics Commission. And as I said, when we get those kinds of complaints, we're going to investigate. We want to satisfy ourselves that there was no violation of the nepotism section of the law. That means we're going to call everybody who was there. We're going to look at all the public records that were available, and we're not going to go away until we're satisfied that there was no violation. And I can tell you, in my experience with the commission, where I was an investigator as part of an enforcement team, and we would handle these cases, and we would get to the end game where, yeah, there wasn't a violation here. And I would communicate that to the subject saying, yeah, we've reviewed it, we're satisfied. Never, ever did I hear from that person where they said, thanks, that was nice, let's do that one again real soon. Because arguably it's an intrusive process, but it's a necessary process. Again, when situations happen, you want to evaluate what the best course is. Now, you have situations where somebody will abstain and they go sit in the audience. And that doesn't violate the law either. Think about my example with Walmart. So I may be a planning board member and I have a financial interest in it. I can't participate, so I abstain, I walk off the board, and I go sit in the audience. Because even though I can't participate as a planning board member, I don't lose any of my rights. I'm still a taxpayer, a property owner, resident. And when the planning board holds its public hearing about the matter, I will be heard as a resident and homeowner, not as a planning board member. You've got to be careful which hat you're wearing. So even though they abstain and go sit in the audience, that's not necessarily an issue, especially if they want to represent their personal views on the matter. And as long as they don't invoke their position or talk about what was said in executive session, then it's not going to be an issue. And then we see issues where somebody abstains and they leave the room. Why would they do that if the law doesn't require it? Well, in a court decision, the judge said in the decision on a similar kind of case, a nepotism case, the wisest course of action is to leave the room. Why would the judge say that if it's not required under the law? Because when you leave the room, you remove all doubt. Nobody can later say you participated, you weren't even there. So in these situations, while all of the examples I provided are legally sufficient, you want to think about what's the best judgment here. I can remain at the table, but somebody might complain that somebody might get the wrong idea. I can go sit in the audience, and I want to because I'm affected by what's going to happen. Or, you know, I've got no skin in the game, so I'm just going to leave the room, or I'm not going to go to the meeting, and then I don't have to worry about somebody making a claim that's not true. Okay, so that's sort of the nepotism section. Now we get to the code of conduct section. I've talked about appearances of conflict of interest. The statutory language involved there is a town employee may not knowingly act in a manner such that a reasonable person, knowing all of the circumstances, could conclude that the town employee would act with bias, that they could be improperly influenced, that they might decide a matter differently than they ordinarily would because the matter affects some component of their private life. And it further goes on that if the public employee files a written disclosure of the bias, it dispels any appearance problem. So legally, the disclosure dispels the appearance problem. Without the disclosure, it's reasonable to conclude that the town employee acted with bias. With the disclosure, however, it's not reasonable to conclude that they acted with bias. Also, the law, this code of conduct section contains other provisions. We cannot use our official position to secure unwarranted privileges for ourselves or others. Those magic words that always look like a $100 bill laying on the ground begging us to pick it up. Do you know who I am? Public employees who push themselves to the front of the line or use their public positions to gain some sort of benefit or privilege that they're not otherwise entitled to. That violates the conflict of interest law. We cannot use who we are as public employees to secure benefits that we're not otherwise entitled to receive. Generally, as public employees conducting the public's business, everything we do is informed by something. There are procedures, processes, laws. Everything we do is guided by something. We don't get to unilaterally decide matters. In other words, we don't get to make up the rules as we go along. Under the Conflict of Interest Law, in any circumstance where a public employee deviates from the normal rules that guide how they're supposed to handle a matter, and as a result of that deviation, someone that the public employee is connected to privately benefits, it's an improper use of public position. Example, so I work for a state agency, and I have one job. I issue a permit. And it's a grand old permit. Everybody wants one. But to get one, they have to do two things: fill out a permit application, pay a permit fee. The word substantial value, when I talk about in the gift restriction rules, the $50 rule, you won't see $50 anywhere in the conflict law. What you will see is an item of substantial value. And that has been defined by the commission to mean anything worth $50 or more. That term, an item of substantial value, appears in this code of conduct section as well. Public employees may not use their official positions to secure for themselves or others unwarranted privileges of substantial value not available to similarly situated individuals. The translation is, if I have to pay for the application, everybody has to pay for the application. So if I have a job where I'm issuing a permit and everybody that wants a permit has to fill out an application and say the fee is $60 to get it up over 50, and everybody has to follow that process. And one day my Uncle Harry comes in and he wants a permit, and I tell him, Uncle Harry, today's your lucky day. Today you get the friends and family discount. You fill out the application, I'll give you the permit, you won't have to pay for it, even though everybody else does. In that instance, I would have improperly used my public position to secure a benefit for my Uncle Harry that he is not entitled to receive. Why? Because in performing my duties, I am not authorized to give out a friends and family discount. Where I unilaterally decided to do that, that is an improper use of public position. Using public resources for any non-public purpose can also constitute an improper use of position. Any abusive private use of a public resource, and when I say abusive, that means it can be quantified at $50 or more. Private use of a public resource can violate the Conflict of Interest Law, and this can involve political activity as well. Campaigns and political activity, that's private stuff. It's not the public's business. And so public resources cannot be used in connection with that. I talked about substantial value. The use of public resources for private purposes has to be able to be quantified at $50 or more for it to be actionable. That means that whenever we get calls from people saying, this person's violating the conflict law because he works for the town and he parks his car in the town hall parking lot and he has a bumper sticker for a candidate on his car. That's a use of public resources for non-public? No, it's not. And in any event, it's, wouldn't be able to quantify that in any measurable way. But so we have to be able to get to $50 or more before it would be actionable. Disclosing confidential information is also restricted under the conflict law. Now, we work in government, we understand public records law requirements, but we also understand that there's some data that we may receive or review that is not public. It's confidential. Everything the Ethics Commission does, for the most part, is confidential by statute. There are exemptions to the public records law. There are exemptions in the open meeting law. Under what circumstances can a board reconvene an executive session from public session, where the public doesn't have a right to see how the public's business is being conducted? So there's some public information that we deal with, public data, and then there's confidential data. In any instance where a public employee receives or reviews confidential information, they are required, under the law governing the data, but also under the conflict law, to keep that information confidential. Any improper dissemination of confidential information, if it's inadvertent, it's not necessarily going to get our attention. Whoever controls the data, it might get their attention. What gets our antenna up? Any improper dissemination of confidential information to further a personal purpose. That gets our antenna up. We had a case involving a clerk in one of our district courts. And the issue involved Corey information. We all know what that is. So this clerks don't have access to Corey information, but there are people in the courts that do. the probation staff. And this clerk had a relative who was running in a local election. And one day this clerk went up to one of the probation officers and didn't provide any context, just asked for the probation officer to run a Corey check on the person who happened to be her relative's opponent in the upcoming election. Not hearing any of the context, the probation officer assumed that it was a legitimate business request, ran the Corey check, got a hit, an arrest record, which he then provided to the clerk. And she then provided it to her relative. And he then released it to the media. And guess who won the election? And then we learned about it. Now, the commission does not have any authority and would not get involved in elections and deciding elections, whatever. We just enforce the conflict law. And the commission did in that instance. And its decision, its enforcement decision, the commission stated, Madam Clerk, respectfully, don't throw us in jail, but even though you are not cleared to receive Corey information, once you did, under false pretenses, you were required to keep that information confidential. Instead, you disseminated that information to somebody not authorized to receive it, and you did so to further a personal purpose. This requirement survives your public employment. The Ethics Commission, in enforcing the conflict law, operates under what's called a statute of limitation. That's a time frame within which the commission can legally take steps to enforce the statute. It's 6 years from the date of a violation. So even in instances where a public employee might learn confidential information, then they leave their public position, if they then improperly disseminate confidential information, they try to leverage it. You know, somebody that works on a procurement team and they're learning how a company bids, and then they leave their public position and go to work for a competitor, and they blab all the information about how this company structures its bids, and they improperly disseminate that confidential information. Within that 6-year window, it is still actionable by the commission, whether you are a current or a former public employee. Okay, we have some advisories. How's our time doing? We okay, or what do we got? All right. Should I kick it up into second gear? All right. I'm just going to talk briefly about advisories. And so if this resonates, you know, if you're an elected official and you need to learn more about how the conflict law applies to political activity, we have an advisory on our website. It's got some pretty good stuff in it, some useful examples of what's allowed, what's not allowed. Generally, these advisories are going to talk about using public resources for a non-public purpose. That's sort of the theme here. You can engage in political activity, you can support campaigns, you can donate to campaigns. If you are appointed, however, appointed public employees, now this isn't conflict of interest law stuff. This is campaign finance stuff, which I'm not allowed to talk about. Appointed public employees are not allowed to touch the money. You can't serve as a campaign chairman, you can't hold a campaign fundraiser if you're appointed. If you're elected, the rules are different, you are allowed to. But you can't use public resources in connection with any sort of campaign or political activity. So both the conflict of interest law and campaign finance law say the same thing, but for different reasons, whatever their law's focus is on. But basically, public employees may not engage in campaign or political activity on public time, in public buildings, using public equipment and supplies. Violations could include approaching subordinates for campaign support or donations, campaign activities in public buildings, or any use of the office's equipment and supplies for campaign purposes. If the town is deciding a 2.5 override to build a new school, and I have children in the district, and I hope the override passes, and I work in town hall, can I go to my office one day, grab a ream of paper, and run off a flyer that I developed advocating that people support the override, and then send it over to the school department, and they use staff time to then put the flyers in all the kids' backpacks to send them home to the parents? And you see how it works. Using public resources for a non-public purpose would violate the conflict of interest. So I had an interesting case where it involved a police officer who was a canine officer. And the issue was, complaint committed was, this officer has a camp up in Maine, and during the summer goes up there every weekend, and they take their patrol vehicle. They're a canine officer, and they're taking their public vehicle out of state. And so originally, oh, we got a good one here. It's an abuse of use of public resources for a non-public purpose. Then we investigated, and it turns out he was the canine officer, but he was the drug dog handler. And when you train a drug dog, it's a lot different than a patrol dog. Drug dogs, they only eat when they train. They have to succeed in a training issue to get fed. That means it's a 24/7 operation. That means wherever the person goes, the dog goes. And so the person had special permission from the department to use the vehicle to travel out of state for those purposes. And so where we thought, oh, we've got a good one. No, we didn't. When we investigated further, if there's a written policy guiding the use of resources and they're following the policy, then that's fine. Okay, we have an advisory on private commercial relationships. You might, as a board member, have dealings with people in your private capacity, if you're a businessman or if you're a public employee, and you're at work, and there are people with whom you have official dealings. There may be people over whom you have official authority. If you're, a police officer, you have authority over people in the town regarding the peace and criminal activity. The Ethics Commission has authority over people subject to our jurisdiction and so forth. If a public employee enters into any sort of private commercial relationship with the same people that they deal with while they're a public employee, that raises issues under the conflict law. At a minimum, if I were to enter into a private commercial relationship with somebody that I deal with at the Ethics Commission, I need to tell the boss in writing that I have this private relationship, this commercial relationship. And also, I cannot use my position to leverage that relationship. If the relationship goes sour, can I take adverse action to retaliate? No. Can I engage in coercive behavior to get a better price or more prompt service using my town position? Hey, this contract may get renewed a lot quicker if you can get your butt over to my house and finish that job. Or, hey, maybe you can give me a cut on the price there and I'll see my way clear to getting this thing that you need from us. You cannot engage in any coercive behavior. You cannot use public resources in connection with initiating or maintaining any sort of private commercial relationship. And at a minimum, a disclosure of an appearance of a conflict will be needed. It's also possible to violate other sections of the law in connection with private commercial relationships, but they do happen. They're not prohibited. It's just care must be exercised to eliminate any use of private public resources in connection with that. Okay, there are also a couple of sections that apply to us when we're not at work, when we're off the job handling our private stuff. If you serve on a board and you also operate a business in the town, understand that when you become a public employee, the conflict of interest law imposes a duty of loyalty on you to the town. And what that means is in your private capacity, you cannot represent third-party interests before the town. Your duty of loyalty is to the town. In addition, you can't be hired and paid by anybody to work on matters that involve the town. Again, it would compromise the duty of loyalty that the law imposes on you to the town. Now, don't panic, because there is a provision in law governing what we call special municipal employees. There's a provision in law that says for those citizens who volunteer to serve on boards for any town position that's unpaid, or to the extent it's paid, it's at less than 800 hours in a year, or by the nature of the service provided to the town, it allows for private employment during normal business hours. Those are for vendors who do business with the town. Those positions are eligible to be designated as special municipal employees. Now, that's important because that designation creates flexibility under the conflict law. Without the designation, I can't serve on a town board and also represent my business before the town. But if the designation has been made, I can represent my business before all town departments, boards, or agencies except the one I serve on. It reduces that restriction. So having that designation is very important. We tell vendors, there are certain instances where a vendor becomes a public employee. If there's a school project that's funded by the Mass School Building Authority and the town school committee has hired an owner's project manager to manage the project, and it hires vendors to work on it awards contracts. Sometimes the employees of those vendor entities become public employees for conflict law purposes. Any key person, if anybody is named in the procurement documents, if somebody's resume was provided because they bring to the table some specialized expertise or service, those folks become public employees. that means they're subject to all of these restrictions. What happens if I'm working on a school building project? I work for an architectural firm or an engineering firm. We're working on the school building project, and then the town wants to build a new fire station, and my company is primed to want to bid on that. If my position as a vendor has not been designated as a special municipal employee, I can't. I can only work on that school building project. But if my position has been designated as a special municipal employee, I can work on the school building project and also bid on that fire station project. As long as in my one capacity I had no responsibility for the other contract, certain other conditions apply. So being a special creates flexibility. And so if you need to find out whether your position has been designated, in most cases they are, Lori has all of that information right up. No, I'm just teasing. So in any event, don't confuse these restrictions with representing yourself. The conflict law is concerned about public employees representing third-party interests before the town or being paid in matters that involve the town. Doesn't affect you and your personal rights. You don't lose those rights because you become a town employee. You can always represent yourself even before your own board. You just can't use any public resources in connection with that. Okay, I talked about special municipal employees. Let's sort of wrap this up. There are regulatory exemptions. For example, if I am a town employee and I'm a parent with children in the district and I want to advocate for my child in the district, I can't because my child is a third-party interest. The conflict law says no. Well, that's silly. So there's a regulation promulgated by the commission which said parents, even if you're town employees, you can advocate for your children before the school department. There is also a statutory exemption that says you can represent your family members before town boards, but only if your appointing authority says it's okay. So a regulatory exemption specific to parents with children in the district, another statutory exemption dealing with representing other family members before other town departments, boards, agencies. There's also one, I don't know if it applies here, but, on the coastal towns where they have, marine fisheries committees, and there's a requirement that the town has to appoint a fisherman on that board. They have, somebody who's affiliated with a given industry. They're allowed, people with specialized connections are allowed to serve on these boards, even if what they will do will affect their financial interest as a part of an industry. That will be allowed. They're allowed to decide general policy matters, even if it affects their industry. They still can't participate in matters affecting their own financial interest in a unique or distinct way. So that's just some of the regulations available. There's also a provision in the law that says if you're a town employee, you may not have a financial interest in a town contract. And that's designed to restrict what we call inside track situations, where a town employee who might have control over jobs or contracts, they can't hoard those. To use those to obtain additional public compensation, those have to be made available to everyone on an open and fair basis. But the conflict law, in order to deal with that situation, has very broad language. It almost makes it unworkable. It just says a municipal employee is prohibited from having a financial interest in a municipal contract. And that basically says if you're a town employee, you can't take on a second paid town job. Or if you're a town employee, you can't be awarded a vendor contract by a town board or agency, or you can't go to work for a vendor in connection with a contract they have been awarded. Now so there's some real harm that the conflict law tries to restrict, but what about situations where there is no overlap, there is no opportunity to manipulate a process? What happens if you work for this department and a part-time paid opportunity comes up in this department and there's no interrelationships at all? What is the harm? There is none. But the conflict law initially restricts that kind of activity, but thankfully there are numerous regulatory and statutory exemptions which allow things to happen. So the bottom line is this: if opportunities come up for second paid town jobs or acquiring a financial interest in a vendor contract, don't assume the answer is no. The conflict law initially says no, but don't assume the answer is no. It may be no, but if when we get these calls, we say, can I take on this second job? No, unless you qualify under an exemption. Whether you qualify depends on an analysis of all of the facts, and there are numerous ones out there. Okay, let's just wrap it up. Restrictions on appointment. Can I serve on the Board of Health, which hires and employs a health agent, and that person is leaving the job, and I think I could be a better health agent? Can I become the health agent if I serve on the Board of Health? And the answer is no. Restrictions on appointments. A board member is ineligible to be appointed to a position hired and supervised by the board until they've been off the board for 30 days. They can apply for the position, they just can't be appointed to the position until they've been off the board for 30 days. That's generally, in the example, Board of Health, health agent. In some instances, yes, we're the Board of Health and we oversee the health agent, but the health agent is appointed by the Board of Selectmen. Well, then that restriction doesn't apply. It's got to be a position hired and supervised by the board that I serve on. Also, there's a selectman's exemption in the law that says I can be a full-time town employee and also serve on the Board of Selectmen without violating the law. But there are restrictions that apply to that, or conditions that apply. In the case that we handled, it was a police officer. He was a lieutenant, and he'd been with the town, very influential, and he wanted to serve on the board, so he ran for the position and won. But the restriction said, if you are a town employee who's also serving on the Board of Selectmen under the exemption in the law, there are 3 conditions that apply. Number 1, to deal with the inside track situation, you can only be paid from one source. You have to decide, do you want to continue to receive your police salary, overtime, court time, detail time, education credits, or would you rather instead take that measly stipend they pay the board? But you have to decide that. Second condition is, when you're wearing your Board of Selectmen's hat, you have to stay out of matters within the purview of the department that employs you. Third condition, you're ineligible for appointment to any other position in the town, period. Doesn't matter whether it's civil service, while you're on the board and for 6 months after you leave the board. And this guy got in trouble because while he was serving on the Board of Selectmen and while he was the senior police lieutenant, senior command rank officer under the chief, the town wanted to create a deputy chief position, a command layer in between the chief and the lieutenants. He was the odds-on favorite to get it. He called our office for advice. We told him, no, you can't. Under this exemption, you are not eligible for appointment. The town appointed him anyways, hoping we wouldn't find out. But we did. We took the position back and whacked him for violating the law. But the town really got pissed off because they wanted him in the position. He was the best qualified. Okay, they appointed him and it was illegal. So all they had to do is, he had to resign the position, pay the fine for violating the conflict law. The board waited for 6 months before they then tried again to fill the position, and they appointed him again. He eventually became the chief. The difference is, when they did it again, it was then legal. The person was then eligible for the appointment because he had been off the board. And then housing authority employees, they're ineligible. Any housing authority employee who also serves as an elected official in the town, they're ineligible for any other position until they've been off the elected position for 6 months. Okay, we're out of time. There's only one more section left. When you leave, don't. Makes it simple. But the conflict law has revolving door restrictions. And what's the revolving door? We kind of think about it at the federal level, where you'll have these elected officials or high-level executive branch officials, and they leave and they become lobbyists, right? Now they're getting paid by these white shoe firms, big money, to represent their interests before the agencies they just work for. Revolving door. At the state level, we have revolving door restrictions. That's basically, there's 2 restrictions. The context is a public employee who leaves their public position today. Tomorrow they go through the revolving door. Now they're representing a third-party interest, a client or a new employer, before that agency they just left. The conflict law says you can't ever do that in connection with matters that you worked on. If you touched it as a public employee, you can't use that revolving door and represent interests in connection with those matters. And then, depending on the nature of your public position, there may have been things that you did not handle, but they were nonetheless under your official responsibility. Like if you're a department head, everything that comes into your department is a matter under your official responsibility. If you serve on a town board, everything that's pending before that board while you are a member is a matter under your official responsibility. The revolving door restriction says that on matters that you handled, permanent restriction. As to matters you did not handle, but they were nonetheless under your official responsibility, you must wait 1 year after leaving the town before you can represent a third-party interest in connection with those matters. If neither condition applies, it's open season. You can leave your agency today, go through the revolving door tomorrow, and represent a client or new employer, as long as the reason for that representation is not in connection with a matter that you handled or a matter under your official responsibility. The last slide is always the most important. When in doubt, panic. Don't panic. But know when the red flag should go up. We've talked about gift restriction rules, nepotism rules, code of conduct rules, restrictions on acquiring a financial interest in another public contract, duty of loyalty requirements, and revolving door restrictions. When the red flag goes up, don't do anything until you understand what the compliance rules are, and that's why we're there. You don't have to be an expert on the law. That's our job. You just need to know to call us. Are there any questions? Yes?
Yeah. Well, my quick question is, can a member of the select board serve on another committee simultaneously? That's ad hoc committee. But the question I really want to ask is about a different kind of situation. If there is a committee or subcommittee that is in charge of certain celebratory programming, and its members are actually the actual organizations that are, representatives of the organizations, some paid, some unpaid, who are invited to submit the programming and take public funds. Is there a problem there?
Could be. Let me just explain. Maybe a good example would be the local cultural council. You have people involved in the arts, and they may want to serve on the local cultural council where they're administering grants that are provided by state or federal agencies, and they also work in the arts, so they would like to take advantage of the grant opportunities. Can they? No. If they're going to serve on the board which administers the grants, then they would be restricted under the conflict of interest law from then applying for or receiving the grants.
This is very interesting. You mentioned the local cultural council, because my question wasn't about the local cultural council, but I attended a webinar by the local cultural council who was saying that they actually encourage artists to participate and still receive funds from them, and they have.
Sure.
So that's. But the question I was asking about.
We know it happens, but.
No, I mean, they were encouraging it, and there were some surprising comments.
Okay.
But the question I had in mind was different. It's where people are actually invited, and they are exclusively promoted as being, recipient of the funds that are provided by the public.
Well, without knowing specifics and knowing that I don't provide advice and the commission doesn't talk about actual situations, I would say I can see a few issues there. Whether there are issues depends on, if we would analyze all of the facts, but I can see where red flags should go up in that instance. I'm not saying that there's something wrong, but those are the kinds of things that need to be vetted. We get into situations where things, look bad, and we would say, look, you can do this, but you should have a policy governing how you do this. And then if you have the policy and you follow the policy, you're going to be okay. It's like if the town, in town hall, if you had open space, a function room, if you will, and you allow the public to use that space, they have to fill out an application, they have to pay a fee. Can you arbitrarily decide who pays the fee and who doesn't? No. Everybody has to pay the fee. Well, we're going to allow nonprofits not to have to pay the fee, but everybody else will have to pay the fee. Well, that's fine. But you should have a written policy which spells that out. And so in any instance where you appoint interested parties to serve on an important committee to decide matters that will affect that industry, and they might be able to take advantage of whatever the benefits that board or committee can provide, there needs to be some sort of written policy governing how that all works. We can't use our public positions to secure benefits for ourselves or to use our public positions in any self-serving manner. So without saying whether something is or is not an issue, I can see where red flags need to go up. Okay, any other questions? Anything on the chat, Chris?
There's nothing in the chat, but if you want to ask them if they want to raise their hand.
If anybody wants to raise their hand and unmute their mic and ask a question, the forum is open. Seeing none, I would thank you all for your kind attention, and thank you so much. And again, if you have any questions, you give us a call. Okay? Thanks.